as there is no constitutional right or statutory provisions which authorize the exclusion of former investigator Dennis's October 17, 2024, or future testimony generally, or the exhibits related to it, the order excluding such evidence was in error and should be reversed. Excuse me. And this is for Detective Dennis and everything that went down last week. So y'all check this one out. This is the state's motion to reconsider oral order striking witnesses' testimony and related exhibits. Comes now, the state of Georgia, and respectfully moves this honorable court to reconsider its October 17, 2024 oral order striking the October 17, 2024 testimony of witness retired investigator T. Dennis and related exhibits, and precluding his further testimony. And y'all saw Doug Weinstein went in on the state, and he made sure Judge Whitaker clarified that Dennis would not be coming back, which he stood on. As a sanction for an inadvertent, stop the cap, non-responsive answer during his testimony. In support thereof, the state shows the following background. During Investigator Dennis's testimony, Investigator Dennis, we're just going to call him Dennis, referred to actions defendant DeMonte Kendrick performed immediately after his release from custody. Defendant Kendrick moved for a mistrial, which this court appropriately denied. How they say she got that right. As a sanction for this event, however, the court struck the entirety of Investigator Dennis's October 17, 2024 testimony, precluded him from testifying in the future, and struck from evidence exhibits which include which Investigator Dennis had authenticated on October 17, 2024. The scope of the state's claim. It is appropriate for the court to strike a witness's answer from the jury's consideration when it contains information the court finds the jury should not have heard and should not consider. The state does not contest that part of the court's ruling. The state submits, however, that the order striking the entirety of the witness's October 17, 2024 testimony, precluding the witness from testifying in the future, and excluding exhibits which had been admitted through the witness on October 17, 2024 was improper and an exclusion of evidence which the law does not permit. The state thus respectfully moves the court to reverse those portions of the court's oral order. And we heard Mr. Armstrong talking about this section to where he said, hey, you really don't have the right to be able to exclude this evidence, especially after it was allowed in. And that's the problem and the issue that they're having with that. Analysis. Evidence exclusion is an extreme sanction and one not favored in the law. State versus Smith, 308 Georgia, 345, 354, and so on and so forth. This is so strongly a part of Georgia law that even the most well-established privileges are narrowly construed as the ascertainment of as many facts as possible leads to the truth, the discovery of which is the object of all legal investigation. And that was cited from Burns v. State. OCGA 244402 provides in relevant part that all relevant evidence shall be admissible except as limited by constitutional requirements or as otherwise provided by law or by other rules as prescribed pursuant to constitutional or statutory authority applicable in the court in which the matter is pending. So this is kind of what Judge Whitaker had to fight against, saying, hey, listen, I have authority to rule over this because this man went on the stand, did something he wasn't supposed to do, and prejudiced the jury. And honestly, she said she could have called a mistrial because of that. But the reason she didn't is because what he talked about is going to be brought up at a later date. But can y'all imagine? I mean, the position Judge Whitaker would have been in if they weren't going to bring up that Yak Gotti had been previously arrested or that he was just getting out of jail. That would have been a major issue. And I would have liked to see what Judge Whitaker did in that case, but I guess we'll never know. That is Rule 402 forbids a court from excluding evidence unless constitutional or statutory authority authorizes that exclusion. Here, no constitutional or statutory authority authorizes the exclusion of the non-offending portions of Investigator Dennis's October 17, 2024 testimony of his further testimony or the related exhibits. Where a purported ground for evidentiary exclusion does not come within the exceptions enumerated in Rule 402, it finds no home in any of the specific and detailed exclusionary rules included in the new code and is unsustainable. Okay, and here's the code here. We don't really need to read through all of that. So we'll skip ahead to this part. This is consistent with federal interpretations of the corresponding federal rule of evidence 402, which has a prospective effect in that it precludes the trial judge from further creation of the new exclusionary rules of general applicability. Interesting. While OCGA 246611 permits a court with control over the mode and order of the witness examination, Rule 611 does not authorize an order excluding evidence and thus would not justify the order at issue here. But it seems like I'm trying to think if the same thing happened with Woody's testimony. I don't think they excluded any evidence that was brought in. Yeah, because when they disregarded all of Lil Woody's testimony that took place after the ex parte meeting and before Judge Whitaker took over, they just excluded his testimony. And I honestly don't remember. I'm trying to think of what evidence was brought in at that point. Maybe a couple social media posts. But from what I understand, the evidence was still left in. And it was actually used at other points as well. Meaning being Monktunk's video that he had on social media and a couple other things. So Rule 611, it says mirrors federal rule of evidence 611 as that rule read in 2011, right? Smith v. State 299, Georgia 425. Okay, all these numbers. Thus Georgia courts look to federal authority for its interpretation. The state submits that federal authority of appeals are very clear. Rule 611 does not authorize the wholesale exclusion of evidence. Unlike the vast majority of the other evidence rules, Rule 611 does not purport to regulate the admissibility of evidence. Instead, the rule gives trial courts broad powers to control the mode and order of what is otherwise admissible evidence. So they can say if it's going to be allowed in or not, but they can't take it out. What? That's interesting. I'm not seeing that there. And let me see what y'all are saying in the chat too. Let me see. Amy says, my opinion is she's giving the state advice, to level the playing field. Could be. Shout out to everybody who's just stopping by in here as well. The state definitely does not want Ashley Merchant because she will definitely cook the state. Well, she's going to be representing Mr. Arnold, who's going to be apparently testifying here soon. So we'll see what happens with that. Unlike the vast majority of other evidence rules, Rule 611 does not purport to regulate the admissibility of evidence. Instead, the rule gives trial court broad powers to control the mode and order of what is otherwise admissible evidence. Although decisions that a court make under Rule 611 may indirectly affect whether proof is admitted, the rule does not provide an independent ground for excluding otherwise admissible evidence. And you know what's funny about this? We talked about this with Judge Glanville when Brian Steele was trying to get him to recuse himself. A lot of these judges rule on their own decisions, which is really weird. It's really strange to see how this is laid out because they're basically saying, hey, Judge Whitaker, you have to make a decision on whether you're allowed to make the decision that you made. And I mean, what judge is going to, I'm sure there's some of them out there, but what judge in Fulton County, I should say, is going to be like, you know what? I probably shouldn't have made that decision. You guys are right. I'm going to say I don't have the power to make that decision. I don't know. I would like to think Judge Whitaker would be a judge that would do that, but it seems like there needs to be maybe the Georgia Supreme Court, like Brian Steele had to do in Judge Glanville's case, that would have to step in for them to say, all right, I was wrong. Yeah, definitely wishful thinking there. Where, here we go. Where a trial court ordered such an exclusion, the Fifth Circuit held the court erred as a matter of law and therefore abused its discretion in relying on Rule 611 to preclude the government from calling the witness necessary to present admissible evidence. Further, the matter at hand does not involve evidence which was illegally seized under the federal or state constitutions, and it does not involve a violation of other rules which have a statutory provision for exclusion, such as the reciprocal discovery rules in OCGA 1716-6. I'd be interested to read that. I wish they had it in here. As there is no constitutional right or statutory provisions which authorize the exclusion of former investigator Dennis's October 17, 2024, or future testimony generally, or the exhibits related to it, the order excluding such evidence was in error and should be reversed. For these reasons, the state respectfully moves the court to reverse those portions of the court's oral order in which it struck the entirety of Investigator Dennis's October 17, 2024 testimony, precluded Investigator Dennis from testifying further, and excluded exhibits which had been admitted through Investigator Dennis on October 17th. And they submitted this that day. Boy, they were quick with this one. And that was Kevin Armstrong, who we just saw in court earlier, and he took that L, as many of y'all know. So, I mean, they definitely make some interesting points. Obviously, most of us are looking at this as non-lawyers, and it seems like they made a decent case. The only thing is, what Detective Dennis did prejudiced the jury, and all the statements made up until that point, everything that was allowed in, it's now tainted. So I don't know. I think Judge Whitaker made the right choice. Y'all have to let me know what you think. This was one of the motions that Judge Whitaker ruled on first thing this morning. So this is a motion in limine number 66. Comes now Jeffrey Williams by and through undersigned counsel, and hereby files this motion in limine number 66 in the above referenced case. In support of this motion, Mr. Williams shows as follows. First of all, shout out to Thugger Daily for posting this. And of course, we know Brian Steele has to put this in every one of his motions. Mr. Williams is innocent of all charges in the above referenced indictment. Do y'all agree with that? If you agree that Young Thug is innocent of all the indictments, and specifically the RICO indictment, type a 1 in the chat. If y'all think Young Thug is guilty, type a 2 in the chat. Let me know. You will not be shamed. You will not be shamed for having a difference of opinion here on this channel. So don't be afraid to type 2 if you think it's 2. The prosecution had on its short witness list the fact that they were going to call Mr. Lamar, aka Rich Homie Quan, as a witness at trial. The prosecution did not call Mr. Lamar as a witness, and tragically, on or about September 5th, Mr. Lamar passed away. Rest in peace to Rich Homie Quan. Mr. Williams was intending to call Mr. Lamar as a witness at trial, however, now cannot do the same. Mr. Williams respectfully asked this honorable court to order the prosecution to not argue or ask at any time that Mr. Williams had the opportunity to call Mr. Lamar as a witness, as same is not true. Further, the prosecution failed to call Mr. Lamar as a witness when presenting their specious theory that Mr. Williams and Mr. Lamar were on bad terms since the fall of 2014, through the year 2015 and beyond. Mr. Williams intends to show the jury that the prosecution sent confirmations in writing that Mr. Lamar would be a witness in the case, but the prosecution never called Mr. Lamar. Thereafter, Mr. Lamar, months later, unexpectedly and tragically passed. Wherefore, Mr. Williams respectfully requests a hearing on this motion and the conclusion of the same, asks the honorable court to grant the above requested relief. Now, Judge Whitaker did deny this one. But Brian Steele did make an interesting point, and something I didn't think it would be a big deal as just a juror who's watching this. So I want to see what y'all think too.